On the recent Mississippi case, the Dobbs case, um, so I'm of course grateful to have a chance to speak on the essential structures of Dasein through the phenomena of the nomos, which here is the law of the so-called highest court, um, which supremacy or judicial review power was established in about 1806, I think, in the Madison case. Which is to say, although it seems to be derived through inferential drawing out of the Constitution's structure, it wasn't in place. So it's a penumbral issue in one understanding of the penumbral, that there are certain things that aren't said explicitly that need to be drawn out and put into a precedent. I have to sort of go into a very Spartan feast of reason here, for the reason that we have both a strong power of that which is either beyond the point where critical reason comes to a halt, the non-rational, and also the interplay of conservative liberalism, or everything beyond Burke, the claim that there's no real ability to do science within the realm of the law, and especially with respect to what Herbert Wechsler is calling the mode of existence of the law, whereby we determine what the is of the law actually refers to, which is to say, does the is refer to a conventionally put down date when the Constitution was enshrined on a certain calendar, Gregorian calendar, some other calendar, but it appeared differently from another angle somehow, or is the is of the law mean what the law has been eternally, so that it has nothing to do with when it so happened to accidentally be put down in a positive way in a document. So you have a large tendency here, I'm noticing, again in this case, to bring in the sole standard of the positive law on the lofty notion that the people or the democratic process must be the origin of, in other words, sort of a Burkean, a struggle of interests must produce the law. So this was one of the arguments made. Here we have, especially in connection to that, here we have an ultimate question, the distinction between life and not life. This is not mentioned, but I'll say it from outside the argument made to the court by the Mississippi attorney, that if we go from the point of view of physics, there's no distinction between the living and the not living. So, say it's a fact that there's something sitting over there, a baby sitting over there. Fact in, from the now current popular acceptation implies that a baby is not a corpse, it's a living baby, and people, as it were, come into their docile awareness of themselves in this notion that there's a distinction between living and non-living things. But the highest authority on what counts as knowledge, physics, says there's no distinction between the living and the non-living. Both are anthropic systems, mass quantitative systems, mass energy systems. So ultimate question is then the question of what is the fact, and what is the is, and all kinds of questions which go outside the parley of Dasein in its vernacular guises and of the court. But the court touches on them by pointing to this standard, which I would call the living natural right standard. So the living natural right standard is being used by the people who are representing themselves as constitutional originalists, which is really just so far as we don't understand the is of the law to refer to something internal, which is to be discovered through the process of the building up of the law, precedents, we must say that the living natural law means just that the people at any given time through, as Kagan was arguing against on the liberal side, the party political sense, as on the liberal side, just like Zizek, the liberal side in the party political sense argues for eternal principles in some form of rationalistic sense, such as the principles which just happen to have been laid out by Roosevelt at the end of the World War II, with various input from the Anthropological Society and other bodies, called the Universal Human Rights Code, which has since then been developed, and which are supposed to stand as something over all human beings, and presumably as, in a way, an eternal law, although it's not stated that way, by saying we want a principle, like Kagan saying we want a principle or some manner outside the latest shouting of the loudest political faction and the composition of the courts. She would seem to point to something beside that living natural right standard of the building up through the people organically creating the law through localities or through the states and so on. The Constitution, if you inferred out of the structure of the Constitution, and you wouldn't need to go far beyond that to the Federalist Papers and so on, you would see immediately that this was not intended by the framers, because the framers thought the grossest form of democracy that would have to be suffered would be the House, and that then you would have the Senate for higher deliberation, and that and they wrote it on the theory that higher deliberation would be considered productive of knowledge, so that you could speak of the lawmaker, the Congress, producing knowledge and not mere nomos, as it were, not mere convention or prescribing the custom of the people, but this would have a scientific standing. In other words, the law is considered a science in the 18th century, the science of the law. And in fact, if you look at the document of the discussion that is attributed to Thomas Hobbes, the lawyer and the philosopher, the distinction made is this. It says the lawmakers are like mathematicians, but the mathematicians make mistakes less often. The lawmakers make mistakes more often, but both are quote-unquote rational. Both are productive of rational knowledge. So if the law is not considered knowledge, but rather the productive of production or the expression, use the phrase of the German jurist, that we can't have, who were arguing against Hegel really, but more vehemently against the French, that the law must be an expression of the living people. So the people, and this is the idea of the living natural right. Natural right is said in contradistinction to what the law as it is on the books at the present time. So the case is mixed because you can't draw a general conclusion about American law from it on the basis that you have the conservatives basically ignore precedent in order to go directly to um, precedent or stare decisis, standing decision. They ignored precedent, which basically covers what we would usually call common law or judge-made law. So they ignore all the law built up over time and say, "Oh, we're only arguing on the merits," and on the merits, we can now tell you what the original Constitution said and didn't say, and it didn't say anything about um, abortion, so this is something added on. And so they make an argument totally setting aside the precedents. But this is not, the problem with this is this which is done to claim over originists is not done consistently. So then you see, for instance, that Scalia um, had no problem bringing uh, in the case on the personhood of the corporations. How was it called? Citizens United versus the Federal Elections Committee case. So in that case, going forward with the practice of bringing in penumbral rights, of the right of privacy, this right of privacy was no, sorry, the right of privacy was analogized to the right of free speech, so that if um, you can expand the right of privacy into the domain of personal life in the contraception case, in the Griswold case, 1964, you can then take other parts of the Bill of Rights, free speech, and extend them to persons in different ways. And Scalia was all for that. So that was a living constitution, a new development of precedents to fit this case. The case did not establish, by the way, the personhood of corporations. That was already long established, and nobody had a problem with it because it's the manner in which a university, for instance, is able to assert property rights not of the chancellor, not of a professor, not of a student, but of the university, which stands independent of any particular person. It's totally reasonable that collective bodies or corporations such as universities should be able to protect property rights independent of any given individual who is happens to be at the moment part of that organization. That's the reason for the juridical personhood of corporations. The issue was this penumbral expansion of new rights out of the Bill of Rights, of speech rights, and then bringing that in to justify certain forms of political speech, which I don't say whether that holding is right or wrong, but I only say that Scalia actively did that, and it's clearly a living, what would eat otherwise put down as living constitution, as he did in the Roe versus Wade case, basically on the question of the so-called substantive due process, which basically, if you give it in the clearest form, it means a state is acting arbitrarily, so that it says we as the state have certain considerations of health and morals and welfare of our population, and we're going to act to ensure that. And then the question comes in, in what spheres can they do that? Can they do that with regard to abortion and so on? And so then, depending on whether you like the case or not, you can take living constitution, or you can take this more nihilistic, conservative view of that all law are. It's usually put in terms of the legal scholar, legal philosopher, which Leo Strauss had some dealings with Kelsen and Hans Kelsen, and of course in the Hartfuller stuff. But the problem here is we're seeing again and again a strong arbitrariness in the way these cases are being taken up, and in the way these kind of ghostly notions of a distinction to the living Constitution and originalists, which are both total innovations, are being used, and how slippery they are. At the bottom of this, it's we can see that there's going to be totally open for all kinds of rejoinders based on change of the composition of the court in the future. And I would say that this gives a lot more fodder to show the arbitrariness of the way the courts are coming forth now. So Aristotle has said that laws are weakened when people see them change rapidly. This touches even on dictionaries, right? So we see people who were used to thinking of dictionaries as something rational then see that words are added just because they happen to be used somewhere, in some locality, or become popular in some way, whether through music or whether through the usage in some specialist field. Term postmodern, for instance, leotard. And if one sees those scramblings, very often one begins to take a different attitude towards the nomos, towards custom, towards law, towards the things that human beings can manipulate and change. And I think in this we should see some awakening. I mentioned, if I can get it in before my time runs out, that it's on analogy with what happened in Prussia in the time of Wilhelm II, where the liberal Protestants against the younger class and against the aristocracy began to insist on the positive rule of not interfering with value judgments and scholarship on history, so that you couldn't present histories which lauded a certain victory, or which were, as it were, anything but a strict chronicle. And in the other sciences, that they constantly insisted on the fact concept as an empirical concept, which overlaps later with, which already was a kind of strange echo of this desire to remove all value judgments except the ones that one oneself held, which we see very difficult to check in our own time. This is now happening on both sides, both parties in America, so that you get a situation where you have a very cryptic hieroglyphic of circuits of different rationalizations, different claims to relatively difficult concepts, which many would say are just, as it were, something to put in the window. One of the justices said, you go to the Moyle and you see stopwatches in the window, and you ask the Moyle, why do you have stopwatches in your window? And he says, well, what would you have me put in the window? It's just getting to be a window dressing of a very complex systems of rationalization, which acts as a hidden cipher language that people uh, must use in certain bureaucratic situations, such as arguing uh, cases to the Supreme Court, but which are probably somewhat alienating to the ordinary public discussion, and create a sort of barrier which, uh, just to end this, I'll say the overarching problem of the antitrust problem of the elite universities from which all the Supreme Court justices are drawn is emphasized in this little episode of this sort of wobble on the Roe versus Wade, on various funny arguments, and on a thorough trouncing um, of the earlier arguments of an earlier Supreme Court, um, in language which resembles this sort of political debate more than, uh, well, not to say that there in a rational debate one hasn't had like a deal of invective and nastiness. It's like Schopenhauer purposes, but uh, so thanks